Good morning, everyone, or whatever time of the day that this video finds you. This podcast would be based on the topic of debt collection. So we've had a number of inquiries received by persons where they would have lent someone monies pursuant an agreement, whether oral or written. And the time has passed for the return of those funds, and they're either unable to get that person to commit to returning the funds, or that the payment plan that was entered into has since been breached, and inquiring of us what should be done. In these circumstances, the court requires you to have exhausted all options with regards to pre-action activities before commencing an action. And that all that is said to say that you're usually required to issue a demand letter or a pre-action letter pursuant to the civil proceeding rules, whereby you're asking that person within X period of time, which is normally asked for it to be reasonable, especially having regard to the quantum of monies that are owed, to respond indicating how they intend to liquidate the debt or when the payment would be paid in full. It normally requires a response to your attorneys either within 7, 14, or 21 days, asking for your legal fees that you would have incurred in asking your attorneys to issue this correspondence to be repaid to you, as well as the debt, and any process server fees that you would have had to incur in getting the letter served on them personally. If the date for repaying the sums pass without a response or without a reasonable response, then you can then instruct your attorneys to commence proceedings either in magistrate's court or high court based on the quantum of the debt. And again, that varies based on the jurisdiction in which the debt has been incurred. And then you will file a claim before the courts with that person being named as the respondent or the defendant, and asking the court to issue an order in your favor. So that could be done either ex parte, where they do not turn up to the hearing, or done in the presence of the defendant, where they would be allowed to enter their evidence, and then asking the court to make an order in your favor. And then once reasonable time, again, the time for repayment would be stated in the terms of the order. Once that has passed, you can then file a judgment debtor summons against that person, or enforce the order in other ways, allowing for that person to understand that there are penalties attached to non-payment. So this podcast was dedicated to informing persons of the ways in which they can recover payments that have been made pursuant to a loan agreement, again, whether orally or in writing, and ways in which they can recover funds that are due and owing under that arrangement, and being mindful that there are statutory limitation periods to the recovery of debts. So you would have to look at what the limitation of certain actions legislation is in your particular jurisdiction to know how much time you have to be able to recover that debt. So we look forward to hearing your views and comments on this particular podcast, because I recall that this issue tends to be particularly topical, especially during COVID, where monies would have been advanced and then persons encounter difficulties in repayments. So we look forward to hearing your comments on this issue. Thank you.